admit to the allegations of violations as filed on the motion in October?
Yes, Your Honor. I have the laws.
All right. Okay. What I'm going to do is order that this pre-sentence investigation be completed. It would be an update of the original one. Is there any kind of recommendation at this point from the probation department regarding disposition in this case, treatment program or STAR or anything of that nature?
They already have a bed for her at Recovery Council.
Okay, when?
Picked up tomorrow at 9:30.
Okay. All right. Well, what I'm going to do is I'm going to go ahead and then I won't order the update. I think what we'll do is there any reason to update the report, Ms. Collins or Officer Benson? Or can we just, are you agreeing with that to go ahead and impose community control without a PSI, Ms. Parker?
Yes, Your Honor.
All right. Find mine here. Okay. All right, Ms. Harrison. Mrs. Collins. Then, is there anything the state would like to say then in regard to disposition?
No, Your Honor. We would ask that she be placed on community control. And as I said, the probation office has already secured a bed for her at Recovery Council, and she's set to go there tomorrow morning at 9:30.
All right, Ms. Barger.
Would just request that you sentence my client to community control, as the prosecutor mentioned, and she is in agreement to go to the bed and get treatment. She understands that she messed completely up by failing to report.
Ms. Harrison, anything you'd like to say?
No, other than I failed, but I went against the rules that the courts handed down to me, and I just messed up. I made a big mistake. Your Honor.
All right. Is the order of the court then that you be placed on community control upon your finding of guilt, and it is ordered that you be placed under community control for a period of 3 years, and that you comply with these conditions? You're to obey all laws of all jurisdictions. You're to conduct yourself in a law-abiding manner at all times. You'll be required to report when and as directed. Be truthful in all statements you make to the probation department about your conditions. You're to keep them informed of your residence, place, and employment at all times. You may not change them either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of a correctional facility, nor may communicate with or attempt to communicate with anyone as an inmate in any of those facilities without prior written permission. You're not permitted to purchase, possess, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapon of any other type. To do so would violate these conditions. It would also constitute a violation of both federal and state law regarding possession of firearms, ammunition, dangerous weapons, which could result in incarceration if convicted in both jurisdictions. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects that are similar to controlled substances or drugs of abuse, or any instrument, device, or thing that may be used to administer them or prepare them for administration. You must have a lawful prescription, and you must provide a copy of that within 24 hours of receipt. You're to submit to drug testing when and as directed. You're not permitted to purchase, possess, use, or have in your control any kind of alcoholic beverage, nor may you be present in places where they're sold or being consumed even if it's otherwise lawful. You're not to associate with anyone who is a co-defendant in this case, nor with any other person that has a criminal group, or has a criminal record, a member of a criminal group or gang, or any other person who has in the past or could in the future influence you to commit a criminal offense to violate these conditions. Unless that's approved in writing by your supervising officer, that would apply to any family members involved in that definition. After the date of this order, you're not to marry or establish cohabitation or common law marriage type relationship with another without written permission. You must report any contact with law enforcement on arrest, citation, conviction, or charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay restitution fees or costs can be reviewed. If you're referred by the probation department for an evaluation or assessment for any type of treatment, therapy, counseling, training, or other educational programming, you'll submit to that. If there's any recommendation of programming, you'll enroll in and successfully complete that during the pendency of this action. You'll be required to pay the court costs and make payment arrangements to do that with the clerk. You'll be required to successfully complete the recovery counsel program and any recommended aftercare. And you'll remain in jail till the bed's available, and that is tomorrow. So you'll remain in jail till they pick you up. Now, by being placed on community control, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your residence, vehicles owned by you, used by you, or any other property place that's under your control where you're found at any time, any officer of the probation department. And you'll sign a written acknowledgement and consent for the probation department. There will be no fine imposed. There will be no driving suspension imposed. The court cost is a condition of your community control. Is also a substantive order, meaning that if you don't make those payments or as arranged with the clerk, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it on completion, then the court could permit you to do community service in this county and give you credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that you fail to comply, and you've already violated the conditions once, you didn't even go 3 months without violating. So if you don't complete your residential treatment and the aftercare, comply with the other conditions, and you're brought back before the court, the probation department will file written notice of what they allege the allegations are. There will be a hearing, and you'll be entitled to have an attorney at that hearing. And if the outcome of that hearing is that you have failed to comply, then at that time, the court could sentence you to a term of incarceration between 6 and 12 months, fine you $2,500. If you're convicted of a new felony while under community control in this case and receive a sentence for that, that sentence could be ordered to be served consecutively to this offense. In the event that should occur, you should be required to serve a sentence in a prison. Upon completion of that prison term, the adult parole authority could place you under post-release control for a period of up to 3 years, meaning you'd be supervised under the conditions they set by a parole officer. And if during that period of time they determine that you'd failed to comply, then at that time they could return you to prison to make you serve an additional period of up to half of the prison term for one or more violations, although there is that is the cap. However, if you're convicted of a new felony, then in addition, whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you for committing this offense while under post-release control in this case to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right. Is there anything further from counsel?
No, Your Honor.
All right.
No, Your Honor.
All right. Then you'll be held in custody pending the transfer to the TRC tomorrow. All right. Thank you. All right. Deputy. Yeah, I'm trying to find my February sheet here for arraignments. Is that did you pull mine out of there, or was that yours you showed me? Oh, here it is. All right. All right. Are you Sarah N. Short, appearing there from the jail?
Yes, sir.
All right, this case number 25 CR 36, State of Ohio versus Sarah N. Short. Ms. Short is appearing in custody from the jail. The prosecuting attorney, Ms. Collins, is present on behalf of the state. The grand jury, Ms. Short, indicted you on February the 4th, along with Michael Carson and Stacy Thacker. There's a total of 14 counts in the indictment. It looks like you've been named in count 7 and count 8. Count 7 alleges that on or about August 29, 2024 in this county, that you and Stacy Thacker did knowingly sell or offer to sell methamphetamine over bulk, less than 5 times bulk. And in count 8 alleges on about the same date, time, and place that you knowingly possessed that amount. Each of those are third-degree felonies, which, if convicted, carry a possible prison term between 9 and 36 months, and a fine of $10,000, mandatory fine of $5,000, and a license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you in this matter, and if you don't have money to hire one, the court will appoint one for you. And I believe I saw a financial statement. Yeah, here it is. All right. Ms. Short, everything on the form says 0, that you're living at Bigelow Street. Who are you living with there at Bigelow Street?
I was living in a camper behind their house. That's my aunt and uncle's residence.
Okay. So when's the last time you were employed?
October.
All right.
Beginning.
And is this the first time you've been in court on this case?
I'm sorry, I couldn't hear you. Your
Is this the first time you've been in court on this case?
Yes.
All right. Court then will find that you are entitled to appointed counsel. Going to appoint attorney Benny Kirk to represent you to enter a not guilty plea in his absence. We're going to set a bail review hearing on your case for Thursday the 27th at 8:30 a.m. That'll be a Zoom hearing. I'm going to set your first pretrial on this case for March the 5th at 1 o'clock. Final pretrial will be March the 26th at 1 o'clock. Your trial date will be set for April the 24th at 8 a.m. And bond will be set in the amount of $10,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, be under house arrest, you'll be under pretrial supervision of the probation department at 117 East Main Street. So if you do make bond, you'll report to them immediately upon your release, and then once a week for 4 weeks after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. Any treatments indicated, you enroll in and follow that during the pendency of this action. You'll be under house arrest at your residence in 302 Bigelow, which means you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case, attend any kind of schooling, job training, educational programming of any sort, and church services. Other than that, you have to be there at all times. If you fail to comply, then that bond can be revoked and you can be held to a further order of the court. Do you have any questions, Ms. Short?
No.
All right, we'll notify your attorney and we'll have your bail review hearing Thursday morning. Thank you. All right.
This guy's here, Judge.
Okay.
He's got a mask on.
Okay.
You be done to come back Friday?
No, we'll go ahead and do it. We'll have to wait until we get down to the others. All right. Thank you. Have a seat. All right, you're Shannon R. James?
Yes, sir.
All right, this is case number 25 CR 017, State of Ohio versus Shannon R. James. Mr. James, you were indicted by the grand jury on February the 4th on 2 counts, 1 tampering with evidence, which alleged on about December the 2nd of last year in this county that knowing that an official proceeding or investigation was in progress or likely to be, you can destroy, concealed, or removed a record, document, or thing with purpose to impair its value or availability as evidence in the proceeding. That is a third-degree felony, which, if convicted, carries a possible prison term between 9 and 36 months and a fine of $10,000. Count 2 alleges on or about the same date, in the county of Ohio, you knowingly obtained, possessed, or used methamphetamine. And that is a fifth-degree felony. Aggravated possession of methamphetamine carries a possible prison term, convicted of between 6 and 12 months and a fine of $5,000 and a license suspension of 6 months to 5 years. Now, you are entitled to have an attorney in this matter. You don't have the funds to hire one, the court will appoint one for you. And I see you did file your financial disclosure form last week, actually a couple weeks ago. And is everything on this form still correct?
Yes, sir.
You're not working?
Not this present time, sir.
I'm sorry?
No.
All right. When's the last time you were employed?
Maybe 3 months ago. Our employment closed.
Okay. All right, then the court will find that you are entitled to appointed counsel. Is this the first time you've been in court on this case?
Yes, sir.
All right. Court will appoint Attorney Danielle Witt to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set the first pretrial in your case for March the 5th at 2:00 p.m. Your final pretrial will be March the 26th at 2:00 p.m. and your trial date will be April 21st at 8 a.m. Now you'll be released on your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony. And if convicted, you could be sentenced in that case, no matter what happens in this case. Now you'll be under pretrial supervision of the probation department at 117 East Main Street. You know where that's located?
Yes, sir.
All right. You'll report to them immediately after we're done here. And then you'll be required to report to them once a week for 4 weeks, and after that, as they determine, you'll undergo random drug testing they may order, provide phone numbers for home, son, employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues, and treatments indicated to roll in. Follow that during pendency of this action. You'll be under house arrest at your residence at 9450?
Yes, sir.
State Route 771.
It's my mom's place.
That's where you're living?
Yes, sir.
All right. You'll be required to be there and be under house arrest at that residence unless you're working, going to and from work, including job interviews. You'll be also permitted to go to and from medical appointments, court proceedings in this or any other case, or appointments with an attorney or probation officer. This or any other case. You can also attend any kind of schooling, job training, educational programming of any sort, and church services. If you fail to comply, then you could be subject to having your bond revoked and be held in custody until further order of the court. You'll also be required to pay a deposit of $171 within 30 days to cover certain statutorily required fees. Have you been fingerprinted, photographed on this charge?
Yes, sir.
All right. So you're going to get an assignment notice with your dates and times. We'll notify your attorney of her appointment. You get her phone number from the clerk. Make contact with her, or him, I should say, her. And then you're going to go down to the probation department for pretrial supervision. Have any questions?
No, sir.
All right. Thank you. All right. Alan Green. All right, are you Alan R. Green appearing?
Yes, sir. Yes.
All right. This is case number 25 CR 18, State of Ohio versus Alan R. Green. Mr. Green, you were indicted by the grand jury back on February 4th of a charge alleged to have occurred on September 17th of last year in this county, alleging you knowingly obtained, possessed, or used methamphetamine. And that's a 5th-degree felony, which, if convicted, subjects you to being sentenced to a term of 6 to 12 months of incarceration, a fine of $2,500, possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you, and if If you don't have the money, the court will appoint one for you, and I see you have filled out your form, and everything on this is complete?
Yes, sir.
Yeah, and you're currently down at TRC, right?
Yes, sir. County Pleas?
Yeah.
Yeah.
All right, so the court will find that you are entitled to appointed counsel. I'll appoint Mr. Wagner. Jacob Wagner represents you, and in the absence of counsel, I'll enter a not guilty plea on your behalf. Your first pre-trial will be set for March the 5th at 2:15 p.m. We'll do that by Zoom. Your final pre-trial will be set for March the 26th. We can also do that by Zoom. Trial will be set for April the 10th at 8 a.m. You'll be required to sign an OR bond at the clerk's office. That's your promise to appear when required. If you fail to appear, then you could be prosecuted for a felony, and if convicted, sentenced on that, no matter what happens in this case. You'll be under pretrial supervision of the probation department at 117 East Main Street. You'll be required to report to them as soon as you get done here. And then once a week for 4 weeks, and after that, as they determine, since you're in treatment, you'll be able to work that out with them, and probably Mr. Farr will do that, drug court officer. You'll be required to undergo random drug testing and may be ordered to provide phone numbers from home's employer. You're already in treatment, so you'll just be required to comply with your SUD, substance use disorder treatment at TRC. And you'll be under house arrest there at TRC, subject to the rules of TRC. So if they give you a pass or something for the weekend, you'll be able to have that. If you violate any of these conditions, then that bond can be revoked, and you could be held till further order of the court. Did you pick up your indictment before today?
Yeah, I went bring it up.
Okay, they photographed you, fingerprinted you, and everything?
Yeah.
All right. All right, then you're going to sign your OR bond in this case. He's going to give you assignment notice for this case, and then go down to the clerk's office to sign your bond, then down to probation.
Right. Where's the clerk's office? I got here.
Downstairs, yeah, right down the stairs, and to your left. Pointed at Jacob Wagner. This is case number 25 CR 19, State of Ohio versus Chadri J. Price. Mr. Price, you were indicted by the grand jury of this county on February the 4th on charge of aggravated possession of methamphetamine. Alleges that offense occurred on about September 17th of last year in this county, that you knowingly at that time obtained, possessed, or used methamphetamine. That's a 5th degree felony, which carries possible incarceration of 6 to 12 months, a fine of $2,500, and a license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you if you don't have the money to hire one. The court will appoint one for you. And looks like you did bring in your form on the 6th, and everything on this form correct, Mr. Price?
Yes, sir.
And you're not working now?
No, sir. I have an interview at Timbertech today, so.
Okay, all right. All right.
Your Honor, could I say something real fast? Catherine Hapner represented me on the misdemeanor side and said for me to ask for her.
Yeah, okay. I was just going to ask you about if you had anybody else representing you. So I will appoint Ms. Hapner to represent you since she's in your other case.
Yes, sir.
And in her absence, I'll enter a not guilty plea on your behalf. We'll set your first pretrial for March the 26th at 2:15 p.m. Final pretrial will be April the 16th. 16 at 2:15 p.m. And the trial will be set for May the 12th at 8 a.m. You'll be released on your own recognizance only, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony and convicted, sentenced on that, no matter what happens in this case. You'll be required to pay a service fee of deposit of $171 for statutorily required fees. You'll be under pretrial supervision probation department at 117 East Main Street, so you need to report to them as soon as you're finished here. After you sign your OR bond, you're required to report to them once a week for 4 weeks after that as they determine undergo random drug tests in their order. Provide phone numbers for home son employer, recommended by probation. You'll be evaluated for substance abuse and mental health issues. Any treatments indicated, you enroll in and follow that during the period of this action. You'll be under house arrest at your residence at 1019 North High Street, meaning Hillsborough, meaning you have to be there at all times unless you're working, including looking for work and interviews, court proceeding or medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of job training, educational programming of any sort, and you can go to any kind of educational programming, as I said, classes, etc., and church services, other that. You have to be there at all times. Were you fingerprinted and booked on this case? Yes. I need that bishop file, Ben. The bishop file. Yeah, okay. All right. Then just go ahead and come right here and get your assignment notice. Go down to the clerk's office, then to probation.
Okay. Thank you, Your Honor.
All right, James Bishop. All right, this is case number 25 CR 13. State of Ohio versus James C. Bishop Jr. You're James C. Bishop Jr.? Are you James C. Bishop Jr.?
Yes.
All right. Mr. Bishop, you were indicted by the grand jury on the 4th of February, alleging that on or about March 22nd of last year, you knowingly obtained, possessed, or used methamphetamine. So that is a 5th-degree felony. If convicted, you could be subject to being incarcerated for a period of 6 to 12 months and fined $2,500 and have a license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you, and if you don't have the money to hire one, the court will appoint one for you. So you have filled out your financial disclosure form. It says you're self-employed, but you don't list any income. Are you making any money?
Not right now because of the winter. I'm making good money in the summertime.
What are you, a contractor?
Please?
What do you do? Contracting?
Well, it's kind of like self-employed. It's handyman stuff.
Okay. All right. Is this the first time you've been in court on this case?
Yeah.
All right.
Can I just explain what happened real quick?
No. We're just here to arraign you, and I can't do anything more than that at this point. Okay. You need to have an attorney before you make any statements.
It was a straight accident. Okay.
All right. The court will appoint attorney Catherine Hapner to represent you, and in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set a first pretrial for you on March the 26th at 2:15 p.m. Your final pretrial will be on April the 6th 2nd at 2:15 p.m. and your trial will be on April 24 at 8 a.m. You'll be released on your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll be required to put up a deposit of $171 within 30 days to cover any statutorily required fees. You'll be under pretrial supervision of probation department at 117 East Main Street. You know where that's located? All right, you report to them immediately after you're released here today. You'll be required to report to them once a week for 4 weeks, and after that, as they determine. Undergo random drug testing. Provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. And if any treatment's indicated, you'll enroll in and follow that during pendency of this action. You'll also be under house arrest at your residence at 6642 Sleepy Hollow Parkway, Hillsborough, meaning that you have to be there unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with a probation officer or attorney in this or any other case. You can also attend any kind of job training, educational programming, church services. Other than that, you have to be there at all times. If you fail to comply, then that bond can be revoked. You can be held in custody until further order of the court. Have you been fingerprinted and booked on this charge at the sheriff's office?
Please?
Have you been fingerprinted and photographed out at the sheriff's department on this case?
No.
All right. After you get done at the probation department, then you go out to the sheriff's department for booking on this charge and tell them what you're there for. So you're going to sign your get assignment notice for your dates and times for your hearings. You're going to go downstairs to the clerk's office and sign your OR bond. Then you're going to go to probation department for pretrial supervision. And then after that, you're going to go out to sheriff's office for booking. Okay, you understand?
The sheriff's office out in town at the lake?
No, out here at the college, behind the college at the main office, so they can fingerprint you. All right?
Okay.
Okay, thank you. All right, this is Bradley Tara et al. Versus Chelsea Sealing et al. Case number 24 CV 274. This is a hearing on a motion to amend a counterclaim filed by the defendant yesterday at 149 e-filed. The plaintiff's attorney is Tyler Trout, is it?
Taylor Trout.
Taylor Trout, and attorney Hannah Bivens, his defense attorneys. This is a Zoom hearing that was set because this matter is set for its final hearing, I believe, next Monday, and so the court wanted to address this as quickly as possible. So I have reviewed the request, and my understanding, Mr. Tyra, from my assignment commissioner, is that Mr. Trout, I should say, that the plaintiff is opposed to the motion.
We are, Your Honor, for a couple reasons. Number one is it's late in the game, Your Honor. The primary reason, my understanding, for the amendment is to seek this court, essentially an advisory opinion on whether revised plans would satisfy or meet the deed restrictions. They've also added some additional words and verbiage in here that seemingly would suggest that they're trying to claim some type of tortious interference or interference with contractors, material suppliers, things of that nature. We obviously have not had an opportunity to perform any kind of discovery on this new report that was provided. I think it's been a week and a half ago. Hannah, you can clarify exactly when that was received. But with my client, if there is an amendment here, would certainly be prejudiced by that inability to perform discovery on these new allegations, these new claims, and also without the ability to perform discovery and depose the new expert on his opinions as to how this satisfies the deed restrictions. As you had mentioned, the final hearing is scheduled for Monday. Very limited time to be able to do much of anything. The current issues before the court for that final hearing is whether the as-built structure complies with deed restrictions. Your Honor had already found in the preliminary injunction order that it does not. So this really is the only new information that has come out since that preliminary injunction hearing, and just the timing of this is prejudicial to the plaintiffs.
All right, Ms. Bivens.
Thank you, Your Honor. I understand the timeliness of the filed amended complaint or the amended counterclaim, but the issue here is this case is really only 4 months old. We've been on a pretty expedited schedule because within a little over a month after the initial filing, we were already in a preliminary injunction hearing where a lot of the factual evidence was already presented. My clients took the approach that they understood the court's position as far as the Port Foundation, and so they tried to seek advice and counsel and come up with a plan to remedy that. They don't want to lose the construction that they have in place. They just want to modify it so that they can comply with the deed restrictions, and I think that that is something that the court should hear. Now, we understand plaintiff's position that they would like some time to be able to depose and get some more information about the report. We had an issue getting the report issued due to the holidays and the weather. The structural engineer wanted to go out and actually physically look at the property. We had a foot of snow that was around for a couple weeks. So that report was issued February 10th, and I believe I sent it to counsel that day.
It was February 10th.
Yeah, and counsel and I had already talked that this was potentially an option we were going to try to see out. So we're just asking the court to amend the complaint if that means we have to continue the hearing for a short period of time. This witness is the only additional information we're going to present, so it shouldn't take much time for counsel to depose and get any additional information. They would need to be fully prepared for a final hearing.
Well, let me suggest or say this, the way I view this. I don't think that this is a proper counterclaim or amendment of a counterclaim because it's going to remedy in future compliance. The issue is whether the building as it sits there today is compliant. The court's ruled already that it's not preliminarily, and in the absence of any new evidence, it would make a permanent injunction. Now, what I see this as is going to remedy or future compliance. In an action such as this, the order of the court would be that further construction is prohibited and they're enjoined until they complete, or until they either one, remove the structure, or two, comply with the conditions. I don't see this as a case where if that the court orders the property to be destroyed, period. Or it would give, just like it would in any other injunctive relief case, like for instance with health department cases or building code, by you're ordered to comply, and the court ruling is that as is does not comply. So this isn't really a cross claim or counterclaim, because this is based on something that's happened in response to the ruling of the court that affects future ability to construct, because the injunctive relief that would be issued, assuming there's no further change in the evidence as to the existing building, and it doesn't sound like there is, but if there isn't, then the order of the court would be, okay, it's in violation, they're enjoined for further construction until they can provide evidence that a new plan complies, at which time the court would review that, and if the court agreed, then it would allow it, and if the court disagreed, then it would order the premises to be, or the structure to be removed, which would then make it a final appealable order, which then could go up on appeal. Now, given that, and that this is a relative, and I understand, with the weather and the holidays and everything that's happened, I certainly understand, and I'm willing to continue the trial if you would like, Mr. Trout, for that purpose, but in the event that your client feels that the court's going to order that property to be destroyed, and that's not going to happen until the defendant's given an opportunity to comply. And so I do think they have the right to comply. Now, whether this plan complies or not, I don't know, because I haven't heard the testimony. It's, the report's attached. It's very brief. And so I would understand your need to do depositions and discovery, perhaps hire or have one of your other experts review it to counter. So I'm more than willing to continue it. But my position is that this is not a matter that's properly brought by a counterclaim. So I deny the motion to amend the counterclaim. But in view of this being relatively new, my only concern is this: is that if I assume that either or both of you are going to appeal the ruling, and I want to get this thing done as quickly as possible because of the time, and also, there's no appeal bond right now, but at some point when I issue an order, there's going to have to be a bond set so that if there is an appeal by either side, and particularly if the plaintiff appeals, that they're going to protect the financial interest of the defendants incurred in terms of delay in cost and damage to what's been constructed and the need to reconstruct and the increase in prices. So I guess what I'm saying is what I see down the road, Mr. Trout, is this. I would most likely, and again, if there's no new evidence, then the ruling of the court's not going to change. It's going to be a permanent injunction. Permanent injunction is going to say you must comply with the restrictions. And if you do not comply within a time certain, I would say 180 days, or present a plan that will comply within 180 days, then it'll have to be removed. If they present a plan and I say it does comply and your client wants to appeal, then at that point there's going to be an appeal bond. If I say it doesn't comply and has to come down, then Ms. Bivens' client's going to appeal. I don't know if there would need to be an appeal bond there or not, because the damages to your client have already been established, that we would assess those. And of course, keep in mind, I'd also have to make a final determination on the on attorney fees and court costs. But my goal is to get this thing decided as quickly as possible for the best interest of everybody, and I'm sure both of you want to do that. So, I guess my question is, do you want a continuance, Mr. Trout, to allow time for that, to prepare for that? Because I'm willing to grant that.
Let let me ask this question from a procedural perspective then for you. If the counterclaim, the amended counterclaim is not the appropriate procedure for the defendants to ask this court for that determination, then is it just a motion to the court to consider the alternative?
After the court issues the injunctive relief, yes. Now, she can present that evidence at the trial, and then all I'll say is, okay, as is, here's the order of the court. It's in violation, and you can't go any further with the plan in place. But if they present evidence that convinces me that that is a compliant plan, then I can say, all right, then you will have X number of days to complete that. And if I say it's not, of course, then at that point, they can take it up on appeal.
Sure. If Your Honor is inclined to allow this new report or alternative plan to come into evidence at the trial, then yes, we would request an opportunity to depose the expert, be able to present that information to our experts for opinion. I'll say we've already talked to one of our experts, and we still believe that it does not comply, but I would like to have the opportunity to more fully explore that, to present that at trial.
Yeah, and that's fine. And again, I don't see this as a claim. I see this as evidence as to what's the remedy or damages. I mean, basically, let's equate this to a tort claim. We have liability established unless there's new evidence that changes that. So now we're on the issue of damages. Well, in injunctive relief, it's the injunction, and what is the scope of the injunctive relief? So this evidence will go to that scope. Because in any injunctive relief, you have to allow for the possibility of future compliance.
Totally.
And just, talking aloud here, I sense from the testimony, as I recall it, that there was basically an objection to the barn dominium type of construction. And again, at this point, I haven't heard evidence that's going to convince me that that is not a proper type of construction. It seems to be pretty prevalent based on the evidence that I've read and heard at the hearings. It may not be as good as other types of housing, but that when it talk about the word quality, does that the quality also includes variations. It can be low quality, medium quality, high quality, highest quality, whatever. So the court's not inclined to get into that determination unless you had overwhelming evidence from the industry that this is not quality construction. And from what I can read and glean from the evidence, it's a growing segment of the construction industry, and it's not in evidence, but just from a personal observation going around the county, we have dozens of these types of homes being constructed and have been constructed. So, it's may not be something that a lot of people like, but people have the right to build what they want to unless it violates the restrictions. So with that said, would you go get the calendar? And we'll go ahead and grant a continuance here. And I guess I'll just include a deadline for any further experts disclosure from defendant, we'll say 2 weeks, and then from a plaintiff, I'll say plaintiff, I'd give you, 3 weeks to identify and provide reports, and then the defendant 2 weeks after for any other expert reports. And then we'd give you, 30 days to beyond that to depose. So let's say that's 4, so we'd be looking about 10 to 12 weeks, if that's agreeable to both of you. Unless you want to just go at it without discovery orders, it doesn't matter to me.
I'm fine with the discovery orders. I think Ann and I can work well enough together that if for some reason we need a couple extra days, then I don't think that's going to be a problem between counsel. But I'm not adverse to having an order either. Hannah, do you have a preference?
No, I don't. I mean, I would like to get back in front of the judge as quickly as possible because, we got this thing sitting out there open to the elements, and my clients, if they can remedy, would like to get moving on finalizing construction.
Right. Well, I mean, construction season's coming up. I mean, we're nearly there. Actually, it hasn't slowed down. They've been building a new house out on West Welcome Road for the last 3 weeks since the freeze stopped. They got put in the foundation last fall or last winter. So, all right. So today is February 25. So 3 weeks from today for plaintiff expert reports would be March 25th. No. See what we got. We got 3 days left, so it'll be 18. So it'll be March 18. And then 2 weeks after that would be April 1. Let's see what day that is. That's a Tuesday. And then I'll put discovery time, I would think, let's say April April 25, that's not quite 30 days. And then we will have the trial. I'll be looking at the trial then the first week of May, maybe. Yeah, let's see here. I could do May the 8th. That's a normal motion day for criminal cases, but I want to get this case decided, so we could do it then, or the following week, the week of May the 12th, I have a criminal case set on the 12th and 13th. So the 14th would be available, or the 16th.
I'm available May 8th, Taylor is. And then that following week, it looks like I don't have anything scheduled right now.
I'm also available on all 3 of those dates.
Okay, we'll make it May 8th, 8:30.
Are we setting that for all day, or does it have to be, Your Honor?
I'll set it for all day
Okay.
at this point, because I want to get this done and decided so that we can, then that'll trigger what's going on.
And I just want to clarify procedurally, at the next hearing, it's going to be for the permanent injunction based upon the construction as is, but you're going to give the defendants opportunity to present evidence on their plan to cure.
Both parties have the right to present any new evidence on the issue of whether it complies. I don't see that there is any. But, and then both parties have the right to present evidence as to the remedy in the injunctive order.
Gotcha.
And that's where your proposal comes in my view.
Yes. Okay.
And then I would tailor my ruling to address that issue in terms of, and let's say I say you can't, that it doesn't comply, then I would say, you'd have another 30 days. We'd set another hearing out 30 days for any other new evidence, because you have a right to comply, but it's, at some point, there would have to be, if you can't comply, then it has to be taken off, removed.
Absolutely.
Or at least down to the, I guess you could put on a garage or something like that, but I actually know the whole thing. I don't want to say that because I don't remember, but I think all the structures have to be that way. Because garages have to be attached, I believe, don't they?
Yes.
Yeah, okay, as I recall. So, yeah, that wouldn't help any. What I think it is, for me, I'd just knock it down and do the foundation and build a barn, but, you can't do that. So anyway, that's what we would do. Now, the other thing is on the issue of attorney fees and on the counterclaim. And quite honestly, Ms. Bivens, I don't think her counterclaim states a claim. You make some allegations, but I don't see any causes of action set forth there. So, basically, and I'm not going to let you amend that now because we're far enough down the road. We need to get this thing to a decision so both parties can decide what they want to do on appeal and or whatever. So what I would suggest is that then the issue of attorney fees be addressed at that time as well, at that hearing on the 8th. And what I recommend when I have these cases is that the attorneys are seeking fees present a bill and ahead of time, and that way you can take a look at it. And then if you want to have a testimony that challenges the sufficiency with you, which is usually through an expert, saying that they're either overcharging, or their rates are too high, or they're putting too much work into the matter, or whatever, that would be the issues. And then, of course, I haven't really addressed the issue of if attorney fees are automatically required or if they're discretionary, if they're permitted. I can't. Normally they are permitted. Yeah, they are permitted because I did have a case here a couple years ago up on 28 in Highland where I enjoined a violation of some plat restrictions, and we did have an attorney fee hearing after that, and I made that award. And the only reason, now I will say this, I want to address the other issue first. That's the more important one. So if we have to, what I think we'd do maybe is bifurcate that and then do the attorney fees after we get done with the other one, because I want to make sure we get enough evidence in on the major issue that I can make that decision. But, under the rule of the Court of Appeals, we have to have a final appealable order, which means I have to have adjudicated all of the issues, which would include attorney fees. So that's why I'm trying to get this all done in one day. So you'll just have both parties will just have one day they have to worry about in terms of appealing. And then at that point, and I would again say, I'm just putting this out now so you'll be prepared to address it, Mr. Trout, is at this point, it would seem likely that if the ruling is adverse to them, to the defendant on that they can't build as is, and the plan that they presented doesn't work, that would give them the right to appeal. At that point, I think there would be the need to put an appellate bond in to protect them. And so you'd need to be prepared to address that. You would too, Ms. Bivens, in terms of how much, because I really don't know. I mean, I know building costs have been going up, but everything's been going up, so who knows what's going on. So,
are you, two questions. Are you asking about the appellate bond or a bond associated with the injunctive relief itself?
It'll be an appellate bond.
Okay.
Mm-hmm. Yeah. And again, what happens is this. If I enjoin them, I'll tell them to either provide a proof of a plan that complies, and I wouldn't go 180 days since they're going to do it at this trial. I'd say maybe 60 days, and if not, tear it down. And then that's the point which they could file their appeal. And even if they were continuing to try to come up with a plan, they could still pursue their appeal, and there would have to be an appellate bond.
From them, though, right? If they appeal, they have to post a bond, if any.
No, I think that there's going to have to be. Well, if I rule against them, yeah.
And
if I rule against you and you appeal,
yes,
then you will be an appellate bond. And I don't know that there would need to be an appellate bond for them because they're not going to. Your client's not going to suffer any further damages. Your damages are not monetary, in my view. I don't think you're seeking monetary damages, are you?
No, only if you award attorney's fees would we then.
Right. Because the issue of market value is be very difficult to prove.
At this juncture, certainly.
Yeah.
I would agree with that. The second question, is there an appetite, since there is, hypothetically, if you find that, if you confirm your prior decision that the as-built does not comply, that the new plan that they're presenting does not comply, and you give them 30 or 60 days to come up with another alternative, is there an appetite to schedule the attorney fee hearing or briefing during that period of time, since we're going to be waiting anyway?
Yeah, probably. I mean, I just hate to postpone that because of the trying to get this to a point where it can be appealed. But At this point, I guess if I'm ruling against them starting construction, then I guess probably another 30 days won't matter.
The only reason why I ask is more often than not the way that I've handled these, and obviously everyone's different, and if you tell me otherwise, then we'll address it all in one day. But there's a decision, an application for attorney's fees, which would also set forth the reasoning for why attorney's fees should be awarded, and then that has a briefing schedule of its own following the hearing. But if you would rather address it ahead of time, we're happy to do that, and we're happy to submit briefing on the issue too.
Yeah, I would prefer to try to address it that time because I'm guessing, you tell me otherwise, but I'm guessing that we're going to have a half a day on the issue of whether this plan is compliant.
Yeah.
And that means we have another half a day then to address the issue of attorney fees.
Agreed.
And I would bifurcate the hearing. I'd get the hearing on the claims done first and then address the issue of attorney fees.
Yeah. I think that's reasonable.
Okay.
Makes sense.
And again, it gets it all done in one day, and I can just write one decision.
Okay.
And then that gets your appellate time. As soon as I get that decision filed, which I would hope to file within a few days, then that gets the appeal time running, and whoever is going to appeal the bond, whether it needs to be a bond or not, and so forth.
Okay. I know there's case law out there that says experts aren't necessarily required to present the request for attorney's fees, but defense, if they want to hire an attorney or an expert to challenge, they can do that, obviously.
That's typically most of the time. I mean, I have had cases. I had a case in Claremont County a couple of years ago where the party seeking the fees did have an expert testify, and I had it most of the time. It's been on the other side, but again, it's up to the parties. So.
Yeah, by that point, when I've done it in the past, there's already been a decision awarding attorney's fees, and now we're just having an expert testify as to the reasonableness of those attorney's fees.
Right. I mean, if I would decide that the attorney fees aren't recoverable, then that would mean we wouldn't have to present the evidence. But at this point, again, I'll listen to any authority. I just recall that the one I had that's maybe 3 or 4 years ago now, where there was a violation of restrictions up on 28 Highland. Thompson, I think, was the case. Thompson versus Cox, I believe it was. And I ruled in favor of Thompson, and we had a couple 3-hour hearing on Cox, because Cox objected the attorney fees, and I made an award, but they had hired an expert, and I did winnow it down a little bit, but that's the way it was handled then. But that was a separate hearing, but because I had to make a decision. There wasn't a preliminary injunction, on that one, and so in this case, we just went to a final trial because it wasn't construction. It was they were dumping materials and so forth on the property, which was against the rules. So, we did stop that, but temporarily, but we didn't have to go to an injunction. So, when I heard the case, I heard everything from the get-go, and then made my ruling. So then that prompted the attorney fee award. So that's why we had the second one. But like I said, on this one going in, sounds to me like the issue isn't going to be right now. Like I said, the issue is at the time this case was filed, was there a violation? I've ruled there is. I don't see that changing unless there's new evidence. So then the issue is in terms of scope, tailoring the scope of the injunctive relief and what opportunities the defendants will be given to cure that. And if I give them that opportunity, if I say, like I said, if I say it is good, then you guys can appeal and you can put up your bond. And if I say it's not, then they can appeal. So, and also the award of attorney fees, whatever it is.
Would you like us to brief that issue of attorney's fees prior to the hearing?
Yeah, it wouldn't hurt. Yeah, it wouldn't hurt. Yeah. It'd save me some time.
Certainly. Do you want to set a schedule for that, or just have both?
Just file it prior to trial, pre-hearing brief.
Okay.
I'll just file a pre-hearing brief. I'll add to that pre-hearing brief prior, 1 day prior to the trial.
Okay.
So that would be May 7th. Unless that's not let's see, what day is the week of this May? May 8th is a Thursday, so May 7th would be a Wednesday. All right, anything else, counsel?
That's all from me, Your Honor. Thank you very much for your time and getting this scheduled so quickly.
All right.
Yes, thank you, Your Honor.
All right, thank you. Alrighty. this is case number 10-CV-487, Atlantic Credit and Finance Inc. versus Mark A. Yankee. And are you James Kozilek?
No, my name's James Rost. I'm filling in today.
James who?
Rost, R-O-S-T.
R-O-S-T?
Correct.
All right. Did you enter an appearance?
I did not, no.
Well, under the rules of superintendents, you're supposed to enter an appearance to represent counsel or to represent a party. So in the future, make sure you do that.
Okay. My apologies, Your Honor.
You're Mark Yankee?
Yes, sir.
All right. So the matter before the court is on a request filed by Mr. Yankee to object to a garnishment of wages. That was issued on, looks like, February 12th. Frog Blasters is your employer. Is that correct?
Yes, they're a sister company. They do all of our payroll.
Oh, okay. All right. And has there been any money withheld, deposited?
Yes, sir.
Okay.
I have deposited. I've paid it in full.
Well, I mean, no, my question was, did they withhold money out of your wages?
They have not.
Oh, have not. All right. So what is the basis of your objection then?
Well, we received that on a Monday, the 17th. My employer did.
Mm-hmm.
It was a holiday. So I contacted Wiltman and Weinberg on Tuesday. I talked to a John Highland and discussed this matter with him. On February the 19th, which was a Wednesday, I sent them a check for $3,390.
Okay. All right. And are you a member of that firm?
I am not, actually, no.
All right.
Local counsel filling in.
So you have no information at all?
I do not have any information on whether...
So I don't understand why you even came. That's the whole problem with these things. They send people who don't know anything about the case, and I'm not shooting the messenger.
Sure, I understand.
That's one of the reasons I require an entry of appearance, and so that we can have a meaningful decision. So, but you have no information at all.
I could take a look at the information you're saying you issued it on. What day was it?
Yeah, but I mean, you have no information from the creditor.
No, I don't.
All right. Okay. Well, I have no reason to disbelieve Mr. Yankee's.
I have. Copy of the check, picture of the check.
Was the $3,390?
That
looks like it's close to pay off because it says here it was $3,383.96 in the.
Well, he upped it up until this Mr. John Highland wasn't sure how this was going to play out, so he went ahead and did the interest. I think until the end of the month.
Yeah. Okay.
So.
All right. Well, based on that, then the court is going to sustain the objection to the garnishment and dismiss it, at the plaintiff's cost. And then, in the event they think they're owed more, Mr. Ross, you tell them that's what they get for sending somebody without the information about the account.
Okay, will do, Your Honor.
All right, thank you.
All right, thank you.
So we'll go ahead and file an entry. Thank you. All right, this is case number 24CV229, Jordan Kibler versus Ebony Foster. Mr. Kibler's not present, but his counsel is present. We're actually starting about 8 minutes early. You're all right to go ahead and proceed, Ms. Brock?
Yes, Your Honor.
And you're Ebony Foster, the defendant?
Yes.
Okay. And you do not have counsel, is that correct?
No, sir.
All right. Well, this is a status conference because this matter was, we had a hearing back in November, and I made some notes, one of which was a status conference of 90 days. And So I believe that was allow some time for discussions about possible resolution. So, Ms. Brock, do you have anything you want to report to the court?
Yes, the home has been put up for sale. I think we all know that during the months of December through about right now, it's pretty dead. I believe they've had a few people come look at it, but they've had no offers yet on it. So we're actually going to ask for a 90-day continuance to allow it to be still put on the market to see if we can get some of that time during the spring months.
Have they signed a listing?
Yes.
Okay, and is that the 6-month listing?
Yes.
Okay. Who's the realtor?
Rachel Cumberland.
Okay. Which firm is she with?
You asked me too fast. Can you remember which firm she was in? I do not, but I'm going to Google her fast. Does she own her own real estate agent? No, I thought it started with the, let's see. But I know we did, you and her had open house, but it was bad out that day.
Yeah. Well, winter, this time of year is not a very good time.
It's not.
But now the sun's shining and there's getting towards spring. It'll be a better time. Although I was listening to a program at noon on my way home that real estate has slowed down a good bit. Well, I was just asking for out of curiosity, but I'm not opposed to a 90-day extension, Ms. Brock. But I guess my question is if the parties have agreed to sell the property that's listed, I'm not sure what the benefit of this case is because the remedy here is to appoint a commissioner and then order it sold at public auction. And I know the parties probably don't want to do that because it's probably not in their best interest. But I mean, sooner or later, I got to do something with this case.
No, I completely understand, Your Honor. Our issue is going to be with the proceeds of the sale. My client has not lived in the property since April of last year, but has been paying all mortgage payments since then, so looking to recoup some of those.
Well, you can't do that through a partition unless we have a partition sale.
Well, we also made a claim for unjust enrichment as well.
Oh, okay. All right. All right, well, we'll set this out about 90 days then. You want to get the calendar in. And maybe you'll have some action, by then. But like I said, I was listening to a program said that the inventory is high right now because the interest rates for 30 years are 7% right now. And home sales have fallen to a 25-year low, I heard, at noon. So, 2 years ago, you couldn't put a house on the market and not sell it in a week. But with the interest rates going up, that's really changed. So,
yes. That is definitely, I understand. I just bought a house in November, so it was a little.
Well, there's a lot of people that are sitting there with 4 or 5% 30-year mortgages, and it doesn't make sense to sell and buy one with a 7% mortgage.
Yes.
So
I'm hopeful. I'm hopeful that they'll start to lighten back up with it being warm and nice. We have a nice 60-degree weather today, so.
Well, that's a good neighborhood, so where the house is, so it ought to be, maybe there'll be something going on. But all right, so February, March, April, May. All right, so we'll go in May, and then at that time, we'll have to set a scheduling order if there's not been an agreed sale. So we're talking about. We'll be out the last week. Today is the 25th, so we'll go into the first week of June. How about June 3rd in the afternoon?
That does work for me, Your Honor.
June 3 at 1:30.
1:30.
And I tell you, since it's just a status conference, we could schedule this by Zoom so the parties don't have to take off work. You can take a late lunch or something, and we could do it by Zoom.
That would be wonderful.
Just need to provide the bailiff with everybody's email information so we can send you the invitation, and then we'll go from there. All right, so June the 3rd at 1:30, and we'll make that a Zoom hearing. Okay. All right, thank you.
Thank you.
right, this is case number 21CR112, State of Ohio versus Sean Van Ness. Representing the State of Ohio is Assistant Prosecuting Attorney Adam King. Representing the defendants, Attorney William Armitrap. Are you Sean Van Ness?
Yes, sir.
All right, this is a motion for driving privileges filed by Mr. Van Ness. Mr. Van Ness was convicted of aggravated vehicular assault and was sentenced, I believe, October 27th of 2021 to a term of 3 years incarceration and a 10-year license suspension beginning 11/2/21. And the motion was filed to grant driving privileges by Mr. Armitrap. So, Mr. Armitrap, anything you'd like to say?
Yeah, I would, as the request states, request for driving privileges, and I furthered up with the last line. His license is expired, so the court today cannot grant driving privileges, but we would ask the court to consider giving him the authority to be able to go take the driving test, and then you can consider privileges if that were to actually happen. I've read the response from the State of Ohio, Your Honor. I didn't represent Mr. Van Ness at the beginning of it, and I can't disagree with anything that's in there. And speaking with Sean, I asked him a little bit about what had happened because I was curious, if nothing else. And he was, to this day, is very remorseful for what happened. And I understand that he pled guilty to the charge, did not take it to trial. And I don't know if these are the victims back here. I don't know them, but the person here, if the motion conjures actors has suffered horrific injuries, and he can't change that. He's like anybody. If he could jump in the time machine and go back, he would. That being said, he took, I guess, an agreed sentence, served every day of it, is not on PRC, did not do any time at a halfway house, spent it all in prison. The fact of the matter is he needs to live, and without the ability to drive, it really hamstrings that, and that is punishment, taking the license for 10 years, and maybe he shouldn't be a candidate for it. But nonetheless, he was doing contracting work before he went to prison, and he would still like to be able to do that. He has a little bit of equipment left, consisting of a couple of dump trucks and Bobcat, that type thing. And if not, he'll eventually have to find some type of a factory job where he can find transportation. So there's nothing he can do to sit here today, nothing he can say that are going to soften what happened to this person whatsoever. He's, like I said, he's remorseful, doesn't change a thing, but we would ask the court to consider, first of all, allowing him to be able to test, and if successful, then to grant him some kind of privileges on whatever conditions the court deemed appropriate.
All right, Mr. King, I neglected to ask, but are the victim or victims or representatives of the alleged victim present?
Yes, Your Honor, a representative of the victim is present in the courtroom today.
All right. All right, what's the state's, anything from the state?
Thank you, Your Honor. The state is opposed to the request for driving privileges. The reasons for the state's opposition are outlined in the memorandum that was filed on February 10th. Just to briefly summarize, this defendant has an extensive felony criminal history. From what I can tell, he spent nearly 9 years of his life incarcerated. In this case, the defendant was sentenced to a term of 36 months, and his driver's license was suspended for a period of 10 years. At this point, he has been out of prison for fewer than 6 months, and as the court is aware from back when this case was handled, the victim in this case suffered extensive and what are likely lifelong serious injuries as a result of the defendant's actions. And the victim's representative, as I've indicated, is present in the courtroom today. She is opposed to this request for driving privileges, and I believe she would like to make a statement at this time, if the court would permit.
All right, and who is the victim's representative? State your name, please.
Rhiannon Cole.
And your relationship to the victim?
I'm her mother.
Okay.
She couldn't be here today. The cold, she gets in an extreme amount of pain when she's cold.
There's a microphone there, so we'll pick you up. Right.
She gets in an extreme amount of pain when she's cold. Winter months, she doesn't get to go out. Thank you for allowing me to speak today. Your Honor, I want you to really consider, before you make that decision to give him driving privileges, this is not a stupid kid that went out and made a mistake one night. This is a grown adult who makes the same mistake over and over and over in the previous, I don't know how many years. He March 21st, 2021, my daughter still breathes, but he took her life. She lays in a bed. She can't never have driving privileges again. Her first brand new vehicle was a wheelchair accessible van that my husband has to work 100 hours a week for months to pay for so we could even get her doctor's appointments. She has had 22 hospital stays in 3 years from infections or major surgeries that she has had to have as a result from what he done to her. Kids change and they grow up and they know right from wrong. This man was almost 40 years old when he did what he done, and he had not had a victim like her prior to that, but has drunk or high. I don't know how and how many other occasions. The next time, what's it going to take the next time for him to kill someone? If you keep slapping somebody on the wrist, they don't learn from their mistakes. At some point, it has to stop where you have to be an adult and take accountability for what you've done. And his lawyer made a good point. Yes, he has to live, and I understand that. But so does my daughter. My daughter gets to live off of $1,300 a month from disability. Half of that goes towards her vehicle payment. She gets the other little $600 for any other medical bills that her insurance doesn't pay, for food, clothing, anything else that she needs. It would be different if he was a kid that made a mistake once, but he's not, Your Honor. He's a grown adult that keeps making the same bad choices over and over again. That's all I want to say.
Anything else from the state? Yes, sir. All right, Mr. Armitrout, anything else you'd like to say?
No, sir.
Well, the court suspended the license for a period of 10 years, and I gave the defendant benefit by starting that to run after he was conveyed to prison. So 3 years of that has expired, but he's only been out of prison for well less than 6 months. Sometime it looks like probably in October of last year. So less than 4 months it looks like. And while it may be difficult for you, Mr. Van Ness, obviously it's a lot more difficult for your victim. And, this is was imposed as part of the punishment. And I won't say that I would never think that you could get driving privileges, but, to apply after you've been out of prison less than 6 months, I think is just asking way too much too early. Because there has to be some accountability. And yes, you served your time, but this was another part of that punishment. Again, it's not a one-off situation. You've had 3 previous, or a total of 3 numbers now, I believe, 3 convictions. I don't know what the previous driving record was. I don't have that. It's not in the discovery. But, given what has happened to this victim, the court does not feel that driving privileges are appropriate at this time. So the motion is denied.
Please rise.